Hello everyone, this is Sachin Sawant, your UK immigration lawyer. I hope the voice is fine. I was trying to go live through my another setup, a new setup, but I'm learning it. I was not able to. Okay, so I'm back to my previous setup. This is Sachin Sawant, your UK immigration lawyer. Today I'm going to start with all the questions on the channel. Anyone who is joining live, they can also ask the questions. I'll try to take as many questions as possible. So the first question on the channel is from Akshay Patel 5900. My skilled worker visa application done, but some problem. Okay. So you have some problem with your skilled worker visa application. I'm not sure what the problem is. So please explain that in by writing any comment. Some salary issues problem. So my result is not directed. So I think your result is not out. That's what you mean. So your application has been pending for whatever salary issues you are referring to. I'm not sure. Maybe speak to your sponsor or they should speak to their lawyer and try to get it sorted with the business help desk. So that is the only advice I can give. Or if you give more details about your problem, then I may be able to help with some answers. Next question, how can I get a copy of my EU settlement scheme approval letter? So they are asking for written confirmation. So this is common people who have EU settlement status approval letters. They come by email, pre-settled, settled, whatever that is, and they tend to lose those. So I had made a detailed video about how to get a copy of that from Home Office. How can I get a copy of my EU settlement scheme? On that you have commented. So you're asking, can you apply without the confirmation from a legal representative? So I'll just explain the context here. So if you are trying to ask a copy of your EU settlement approval letter from Home Office, that is a subject access request that you have to make. In order to make that request, the person who is making the request has to prove that he is the person he is claiming to be. So if Mr. A is asking for Mr. A's document from Home Office, then Home Office wants to make sure that Mr. A is the only one who is asking. That is the data protection laws. Anyone cannot just ask Mr. A's documents from Home Office. So that's why there is a written confirmation. So there is like an attestation. A passport has to be stamped by some legal representative. I do it myself. Anyone can do it. Solicitors do it. Legal representatives do it. So, but then you need a copy to be attested and confirm that that is the true likeness of you. Only then Home Office will give you anything on your record, whether that is the pre-settled status letter or anything that you're asking for. So your question is, how can I apply without this, please? You cannot apply without that confirmation from the solicitor lawyer. You have to, we do this for many clients. You can either come to us or get it done by any other lawyer. But you need that because without that, Home Office will be just giving data to anyone and everyone who is just asking about you. So next question. Me and my wife are both on skilled worker visa. My wife later switches to dependent while I continue being a skilled worker. All will the time reset? Okay, yeah, this is a common question about time reset. Both husband and wife are on independent skilled worker visas of their own. If one of them, if the wife switches and becomes a dependent, her time will reset for ILR. She will have to complete a full new 5 years for ILR on that PBS dependent route. So that is the answer. Yes, her time will reset. Next question, if we have registered our business May 23 on tier 2, later on got ILR in August. Okay, this question is about, so you were on tier 2 visa, you registered a business in May when you were on tier 2, you got ILR in August, that is after that. Could you please suggest where I should register our changes of visa status? So this is not a Home Office issue, UKVI issue or UK immigration issue. Maybe speak to your accountant if there is any updation required with HMRC. I'm not sure HMRC even cares about visa statuses. But anyways, speak to the accountant and get it updated with HMRC records. That's what you need, I think. So I don't think it matters much, but anyways, I cannot advise on that. You have to deal with HMRC or company's house wherever you want to update. Speak to an accountant for that. Okay, both parents managed to get sponsored care visa after spring 24. So under the new rules, the children are living in the UK. Will they be able to get dependent visa? Thanks in advance. Yes, so I understand where your question is coming from. So after April 2024 sometime, the government has suggested that they will be not allowing dependents on the care worker visa. So if both parents to get sponsored. So this is, yeah, this is a common, these are the questions I am always asked. So I will just clarify. Anyone who is already on the skilled worker carer visa, they don't have any issues. Whether the dependent is already in the UK or it is the dependent is not there, whether child, husband, wife, whatever that is. If you are already on the care worker visa, you are perfectly sorted. You don't have to worry about the changes of dependents not allowed. I'll answer that live question, but let me complete this one. So only anyone who is going to get the care visas after the change date, let's say if the change happens on 1st April, for example, then anyone getting from 1st April onwards, only the changes will apply to them. That person cannot bring dependents. So your question is, if both the parents get independent care worker visas after that date, after the change, can they sponsor the children? Yes, definitely. Let me think. Dependents. It's not clear because the rules have not been made. So I'm not sure if they will be allowing the children. It will be a tricky one because the intention is to not allow dependents, and children would also come under dependents. So I think for now my answer is no, from whatever clarifications I have from fact sheet. If both the parents get, that doesn't change the rules for the children. The children are still dependents. They may not be able to join your. Okay, Musicify, a live question. Is there any way that parents can get any type of visa as dependents from a UK lived child for continuous 7 years who was not born in the UK? Yeah, if the child is not born in the UK, there is no straightforward method of getting ILR for the child. Maybe if the child spends 10 years or so, then maybe you can try citizenship or something like that. But all those applications are discretionary. So 7 years child who is not born in the UK, the child itself may not get ILR. It is a difficult one. I'm not sure Home Office will give that. It's not provided in the rules. So then if the child is not getting anything, parents are completely out of question, if that is what you're asking. Next question. Currently, I'm on a graduate visa. I'm under 26, recent graduate. If my company wants to assign a course, but I have 21K annual income, new entrant visa, I'm eligible for this salary. Can I get 5 years skilled worker visa for the new entrant? Yeah, this is an interesting question. New entrants cannot get 5 year. So if your salary is given as a new entrant, it can only be, so the calculation is no, you cannot get a 5 year visa as on the new entrant salary. So that's a clear answer. I know that. I have studied those rules. I have also made a video on that new entrant visa. So a new entrant salary can only be paid up to 2 years or so. I think that's how I understand it. But you, for to answer your question, you cannot get a 5 year visa. So that is my answer. Next question, you repeated the same question 3 times. Okay. Next one. Hello sir, my wife failed in university, but she completely all the study, and after that I can apply for sponsor visa or not, please. After she failed in university, my complete. Okay, so your wife failed in the university. She attended the course fully, studied in the university. After that, can you apply? You are the dependent for sponsored visa or not? You can apply for the sponsored visa anytime. A dependent can switch to a skilled worker visa. There is no restriction on that. Whether your wife studies at the university or doesn't, I think the dependent is not affected. After she fails the university, might complete the study. So yeah, if she has fully completed the course of study, even if she fails, you dependent can become a skilled worker in your own right. You can switch from dependent to skilled worker main, and your wife should be able to switch if she has completed the course of study. She may not have passed it, but the completion of course of study is important. Next question, facto. How can apply for work visa? Okay, yeah, you need to speak to an immigration lawyer. That's quite a detailed advice you're asking for. Skilled worker visa is a sponsored visa. You always need an employer who is willing to give you work, give you sponsorship, and then you can apply for the skilled worker visa. That's how the work permit, UK work permit works. That's my summary answer. Neelark, I am a chartered accountant waiting for DCOS, which was applied 10th January 2025. When can I expect the DCOS? DCOSs are taking a lot of time. Yesterday I was on a call with our immigration lawyers, other lawyers as well, and everyone said that they are taking a lot of time. Home Office still says that they are giving it within 2 weeks. We are getting all our DCOSs within 2 weeks, that is for sure. But if it's a specific industry, for example, building trade or care worker, care homes and all, they are taking a lot of time. Those DCOS requests are triggering an audit or something. Sometimes home office is doing audits of the sponsors and all, or they are doing their own research to find out if there is any wrongdoing involved. So 2 weeks is the standard time for a DCOS approval on normal cases. Is it fine? Like so much if a child is born in the UK and lives 7 years continuously is eligible for ILR and parents can apply for dependents, right? Yes, you are right. Child born in the UK and spends first 7 years of his or her life in the UK can apply for indefinite leave to remain after 5 years, after 7 years in the UK, sorry. And on the basis of the child, the parents and any siblings also under 18 years of age can apply as the child's dependents under the family route. Okay, next question on the channel. So I'll take live questions and also whatever the questions are on the channel. The new resolution channel take student. Student must require English test or okay, the question is, maybe I'll try to interpret it as much as I can. Would the new rules salary threshold implemented on the 2023 Jan intake student? New rules for salary threshold. Yes, it will apply to everyone. So if you are a student and you come on the January threshold and then you change to the skilled worker visa, obviously it will apply to you as well whenever you change it, because definitely you will be changing to the skilled worker visa after completing your course of study, and that would definitely be after April. So it will apply. There is a yes for English test or UKV IELTS if we did not complete the degree. If we did not complete the degree, yeah, successfully. So you completed the course of study and you're switching to a skilled worker visa. Yes, you will need the UKVI IELTS or UKVI TLS, whatever those other companies are for the English language, because you did not complete your course of study. Thank you, Mrs. Sufai. Okay, next. English test is a must. Yes, English test is a must for skilled worker visa. How many types of tests can we give to the skilled worker visa if a student is inside the UK and completes the course duration? Try to convert the visa. Yeah, there are many English tests you can give. Just Google search for UKVI approved English test centers in the UK, and then you will get all those. There is PTE, I think there is Trinity College, there is IELTS, there are many others. So it should give you all the information about who are the test providers. Test requirement remains the same, B1 in all four components: speaking, reading, writing, and yeah, all four of them. So you need B1 in all four for a skilled worker visa, whether you're doing an entry clearance application or inside the UK. Okay, not in the UK as well, but this should be normal case only. No additional info is asked from the employer. Yeah, usually it is taking 2 weeks. So the question is about you are a CA in audit in the UK, and the normal case, the way I am referring to, is if there is any wrongdoing, if the visas have been purchased, sold, if the employer has any compliance issues with the sponsor license, I don't know. I cannot just tell you on the job code. So whatever licenses we are managing, we know that everything is clean and out. So I know that I can vouch for that. But I don't know how everything is working with your proposed employer. So for the job code, I think it should be fine. You are already qualified CA or something, but there are many other factors on Home Office's list. Okay, Mark, can I apply for spouse visa before 6th of Feb and evade the 66% increase? 6th of Feb, 66% increase. So are you referring to the increase to the immigration health surcharge? Please clarify, Mark, or the financial requirement, which is going to come later. So I think you are talking of immigration health surcharge, but clarify, it will be better for me to answer. Okay, English test is a must. Okay, a curtail visa is reinstated. Do we need to apply for a new BRP? Curtail visa reinstated. I don't think there is any procedure where a curtail visa can be reinstated. To the best of my knowledge, there is no provision in the immigration rules where if a visa is cancelled by Home Office, that means they have issued the email saying you have 60 days to do something in the switch to another category or leave the UK, it cannot be reinstated. So I'm not sure what is that you are referring to. Visa instead, do we need to apply for a BRP? But if anything before that has happened, let's say the employer has reported the last date of job and then they withdrew that reporting, you don't need to apply for any VRB. So I'm just trying to answer on both sides. Yeah, because IHL will be increasing by 60% 6th of February. Yeah, if you apply before the effective date of the increase, I know they keep on changing that date. Earlier it was 16 January, probably some 10 days after that. Now I've heard 31st Jan. Now I think there is a new date, 6th of Feb. Yeah, if you apply before that date, then it's the date of application that matters. The date of application is when you submit the application, which means you pay the UKVI fees and you pay the immigration health surcharge. No, sorry, you pay the immigration health surcharge first and then you pay the UKVI fees. So that is called as, once you pay the UKVI fees, that date is logged as the date of application. So make sure if 6th of Feb is the date of change, you submit the application before that. Make the payment of the UKVI fees, which is the second fees in the process. Okay, what are defined and undefined certificates? Okay, so adhere to visa for first three was for 3 years and change to healthcare visa for 2 years extension. Okay, but unfortunately I can't apply for ILR due to fault and they lose 1 month on my continuous stay in the UK. 1 month extension. Okay, so this is also a common question. So you were on a tier 2 visa for 3 years and then health and care visa. So basically the same category, whether tier 2 or skilled worker, even if you are on that health and care visa. So 3 plus 2 and you are short of 1 month. I think that's what your calculation is for the ILR. You are not completing the whole 5 years for whatever reason. You can still apply within the last 28 days of completing the 5 years, but I think you may have already calculated that. But you are short of 1 month. Yes, you can still extend the skilled worker visa, the care worker visa further. You can file for the extension anytime before the last date of your end of permission as a care worker. So 28 September you said, so any date before that or latest on that date, you can apply for extension of your care worker visa. Once request is received, next question, Neela. Once request is received, can you help with visa application as the same is to be made by me on my own? Yes, we can help with the visa application. Yeah, so to contact our office, yeah, click on the YouTube bio or whatever that information thing is and go to the website and fill up the contact form or call our office and someone should get back to you on that. Yes, we can help with applications. We do everything. We represent employers, employees, jointly, both of them, everything. So, can a failed student switch to skilled worker visa? In my case later, my course completion date is 31st October. I noted my course from 2 year to 1 year. Okay, I will use my course on 19th January. My results will be declared on 22nd February. Can I switch to skilled worker before that? I'm asking before I do not. I want to not have revised case letter. I want to apply for a visa before I just buy start. Okay, so this is an interesting question for me also. So in your case letter, you had a course end date of 31st October 2024. However, you changed your course, whatever happened from 2 years to 1 year course, and you completed your course on 19 Jan 2024. Your results will be out by 22nd Feb. Can I switch to skilled worker visa before that? Yeah, you can switch to a skilled worker visa provided you get a letter from your university. So CAS is one by default option where the caseworker will look at, but make sure you do representations, do it through a lawyer or explain it in your covering letter stating that what has happened, your course end date has been preponed, and get a letter from the university stating that your course has been completed and whatever the reasons they can state on that, and it should be fine. If your course is completed, your course is completed. That's how immigration rules work. CAS letter is one of the ways where they get the information, but the second thing would be a letter from the university confirming that the course is completed. You may be able to switch to the skilled worker visa if you get that letter and your work started is after the end date of your course completion date as stated by your university. It may be possible, yeah, but for detailed advice, specifically, I know your timelines are very tight and you want to save on the immigration health surcharge increase. Speak to an immigration lawyer and get the exact dates when you should file. Thank you, Neela. Thank you, Mark. Okay, next question. Can a person who is on IT skilled worker visa, can he shift change to care worker visa, skilled visa, or any other work visa profession other than IT? Is it allowed? Okay, so if you are on an IT skilled worker visa, so your job code is some IT work, whatever project manager, IT, software, and all. You want to change to a skilled worker visa under the care worker category, care worker visa. Yes, you can, provided your employer is able to justify that you are able to do the job and why they have given you that employment. So, yeah, it may seem odd to the caseworker or something, but make sure you have enough justification to show why you there is such a big downfall from an IT related job to a care worker job. Maybe your employer may have to justify when they apply for the DCOS or something, and in your application as well. It is possible. Immigration rules allow you to do that, but on the genuineness, there may be question from the case working. Okay, my wife has a B2 certificate we used in the first spouse application. Now the certificate is expired. Can this be used again for the extension and INR? Okay, yeah. So this is also a common question on the spouse visa. I have separate videos also explaining that. So yes, you can reuse your expired English test certificate if it has been used previously used for a successful application and you are continuing on the same route. In your case, your wife is on a spouse visa. On the first spouse visa, she used the B2 test. So for the spouse visa, the levels are A1 minimum levels that the Home Office expects is A1 is for the first application, A2 is for the extension, and B1 is for the ILR. If your wife has already passed B2 in the first one, she can keep on reusing the certificate for extension, for ILR, for citizenship, all of them, even if that certificate is expired, provided she is having continuous leaves. So she is continuously, what I mean is she had the first visa, then she extended, then she got ILR, and she's continuing. So yes, it can be reused. I have changed my job 2 times. Last year, when I count the total of 12 months, I have more than 8600. Can I apply for ILR with that? Okay, two-part question. First is on the salary 18,006. I have changed job 2 times in the last year. When I count the total of 12 months, I have more than 18,600. So if you have changed jobs, then there is the formula works very weirdly. There are two things that the caseworker will look at. Your current salary should be higher than 18,600. So your letter from the employer should be confirming that. And second part, you should show evidence that payslips, bank statements to show that you have already earned 18,600 in the last 12 months gross amount before tax. So those are two requirements. So your current job, the important thing that I'm not sure whether you clarified it, in your current job also you should be earning 18,600 or higher. That is important. Second part of your question, for the spouse visa, your BRB expires on 15 June, 60 months, 5 years on 2nd of March 2024. So yeah, this is common with spouse visas because spouse visa is given for 33 months first and the extension is given for 30 months. So totally you get a visa for 63 months permission. Uh, so you can file for ILR as soon as you reach the 60 months mark. So yes, if you are completing 60 months on 2nd of March 2024, but your BRP is still valid till June, you can apply in March when you complete your 60 months or within 28 days of that. You can apply earlier after completing 60 months. No live questions. Okay, can I fail? So, okay, I'm working in accounting firm. Employer is going to sponsor me before the last result come out. Oh, yeah, he said, hey, there's my issue for your exam. Let's see what accounting firm is giving visa process services as well. We have a lawyer for that and with experience question. Okay, not sure what is the question. Applied in one exam. Okay, this is just a comment. Seems there is no question in this. Okay, so yes, if you have so Hamzio, if you're asking, I'm not sure what your question is, but I'm trying to interpret. So you're working in an accounting firm and you have failed. That is the update. I think you received a provisional result and you have failed in one of the exams and you asked for transcript, gas letter. Sorry, this. Yeah, I think these are just comments on the channel. Next question. I can't get pre-settled status for my wife. We meet for the first time after 2023 we get married, a baby for maybe they give pre-settled status, but for my wife no, because we don't have proofs of relationship before. Now she was refused. Can't apply again. Yeah, so this is a problem with the EU settlement scheme. If your marriage has not happened before, if your relationship did not exist before 31st December 2020, your wife will not qualify for EU settlement scheme. Your wife will have to apply for the spouse visa under the British immigration rules, which is a paid application with the immigration and surcharge, etc., etc. That is the goal of the caseworker. Whenever they refuse, they want you to apply on the British immigration rules and pay whatever those exorbitant fees are. So that's the reason it is refused, because in the EU settlement scheme, the provisions are very clear. If your relationship has started or you got married after 31st December 2020, then you have to apply under the British immigration rules. Separated EUSS durable. Okay, my friend has a child with an unmarried partner and his child is British by birth due to a mother. Okay, she is 4 years and 6 months. Can he use his retained right? And he will. Yeah, you don't get retained rights with. So the retained rights under the EU settlement scheme, you don't get it with unmarried partners. Unmarried partners are extended family members under the previous EE regulations, and durable partners, what they call under the EUSS. So the facts of the case are your friend has a child with her unmarried partner. The child is British by birth, by whatever that is it, and she is 4 years and 6 months. So the child is 4 years 6 months. Can use his retained rights, and this will complete 5 years in November. Yeah. I doubt whether he will get it on the unmarried partner, because he has not had anything. You have not clarified what visa status the person has. I'm assuming he doesn't have any status. But on the partner with the unmarried partner status, you may not get anything on the retained rights. If you have EU child, let me check. I'm trying to see if you can apply on the basis of the child. Okay, no more live questions. Fine. Retain rights of residence. Okay, I'll take that live question. Let me just make answer this one. This has died. If you are in education, if you can apply for education, okay. If you are previously married, okay. You have custody. Okay, on the basis. Okay, so the question is on the EU settlement scheme. Unmarried partner, you cannot apply on the basis of unmarried partner for retained rights. Uh, Retained rights under the pre-settled status, settled status, EU national. On the basis of the child, I was trying to see if you can apply. No, you cannot apply on the basis of the child as well. If since the child is British, you may be able to apply for a parent visa or something if you have sole responsibility or joint responsibility, but that will be under the British immigration rules. So under the EU settlement scheme, your friend will not be able to apply. So that is the answer to Arabica 7263. Okay, live question. If the immigration officer stamped in passport, what they information keep? Yeah, when they stamp the passport, I don't think, I'm not sure whether they keep any information. I'm not aware of that. I may not be able to answer that. I don't think they keep any information, but I remember if you have a BRP card or something, they scan it, the system would record it when they scan your passport. So definitely they would have some record of you. Uh, that is for sure. Next question. Can we apply for priority service for allocation of defined costs from home office for healthcare visa? Yeah, this is another common question that I get asked. For defined costs, whether for healthcare visa or for any visa, there is no priority service. I know for healthcare visa, defined costs is there is the timelines are very long, 2 months, 3 months, even 6 months. Some of the care homes are being waiting for. Home office is just trying to audit, investigate as much as possible because there have been a lot of frauds in the care worker visa area. So yes, I know many of you may be waiting for those decauses, the employers, the proposed migrants who want to apply, but there is no priority service for defined certificate of sponsorship. Okay, my brother has a restaurant. He's trying to get skilled worker visa. Can I go on that visa? Okay, so the question is your brother has a restaurant. He's trying to get skilled worker visa. So if he has a restaurant, maybe if you mean if he's getting a skilled worker visa, you cannot get on your brother's visa. There is no way you can do that. But yeah, if you mean your brother has a restaurant and then he's going to apply for a sponsor license and he's intending to sponsor you for a skilled worker visa, that may be possible depending on the genuineness of the job, genuineness of the business, a lot of other factors. Speak to an immigration lawyer and get advice on that. Yes, it may be possible if everything is genuine. Your brother can sponsor you if the business is genuine, if the position is genuine, everything is genuine, but not just because you are the brother. Okay, can I ask you something about dependent visa of student and the PSW? Uh, Dependent for student and the PSW. Okay, are they will accept sponsorship from a care home as a CA dependent? So already been in the UK for years. Are they able to add their dependents into that visa or? Okay, so there are several parts in the same question that you have asked. I'll answer this one and then I will take Krishna your live question. So about dependents of care worker visa holders, someone who is already in the UK as a care worker, whatever the job codes are, 6145, 46, you don't have to worry. You can still bring in your dependents. That has been clarified by Home Office in their fact sheet, and that's a detailed explanation over there. I have studied that one. So see, care workers who are already in the UK, they can bring in their dependents even after the change comes into play of the dependents not allowed. The change will only impact someone who gets a visa, the main applicant getting a visa after that date. So, can I depend visa of student? Okay. So I think from what I understand is if you already have a visa, so this is my summary answer to whatever you are trying to ask me over here. Uh, Yeah, so that is the summary answer. If you're already on the healthcare visa, then before the change happens, then you can bring in your dependents or your dependents can join if they're in different categories, whatever that is. But anyone who's getting a new healthcare visa, they after the change happens, they may not be able to sponsor dependents. That's the government's intention. That has been clarified in the Home Office fact sheet. Krishna Kumar, live question. I am running a retail business, just 1 month old. I am on PSW. PSW, okay. If turnover is very less and I get all docs, is it easy to get sponsor license for? Okay, so I'll answer in parts. Turnover is very less. I don't think the turnover matters. It's basically Home Office will definitely check the funding and all. How are you going to fund the business? How are you going to pay the salaries and all of that? If you're asking for a sponsor license, so whatever that is, a venture capital is investing in you. You got a loan, letter of credit from financial authorities, whatever banks, etc. But something about your finances will definitely be queried if you just opened it just 1 month old and you're on PSW if turnover is very less. So my advice would be improve your turnover, improve your business. If your business performs well, then it would be much easier for your business to get a sponsor license and continue from there. Next part of the question, I get all the documents. If you have less turnover, there will be more questions asked by Home Office. Simple. Is it easy to get sponsor license? Yeah, it's not about easy or not. They will definitely check the genuineness of the business, whether the employer can afford salaries, whether the person they're trying to sponsor is a genuine employee. If there is, so if you are just trying to circumvent the rules by setting up your own business and try to sponsor yourself, it may or may not work out. So that's something that they will always look for. AO level 1. So what about AO level 1? Can I be my own? If it's in your own business and you're trying to do and you're on PSW, yeah, it would. I would not recommend that. They will not even approve it because you're on PSW. They will need a settled person to be the authorizing officer. Okay, but if applicant apply for 20 years long residency, the Home Office check travel history through passport. Yeah, so through passport, I don't think they can find much. If you just entered once and never returned back, you have to just give whatever passport you have, copies, anything. They will try to find any records they have, but if they have anything against you, obviously they will put it forward. But then, yeah, whatever you have, maybe just one stamp that you entered 20 years ago, that should be sufficient to prove that you are in the UK. And any other evidences of every year, you will have to produce that. Yeah, we've done many applications, yeah, and explained to Home Office. They do come up with weird questions, weird ones. But then, yeah, it can be sorted. If you are genuine, if you have not left the UK, you have remained in the UK for 20 years, you just have one passport, and or sometimes people don't even have that passport. I know we have to go on explaining from wherever we are. Uh, yes, if applicant apply for 20-year long residency, the Home Office check travel history. Yes, if in the passport there are stamps and all, definitely they will check it, whatever you present to them or whatever records they have. That is my answer to your question. Music 5. Do you have any idea that international students can do the 6-year part-time PhD from a university in the UK? Sorry, I cannot advise you on that. That is for the university. Maybe speak to the university. I can only advise on the immigration front. Speak to the university on whatever qualifies for a student visa or what doesn't qualify on that part-time PhD thing. Okay, next. If the person is a pensioner in the UK, can you apply for a spouse visa? Yes, if you are a pensioner in the UK, you can apply for the spouse visa. You will definitely have to meet the financial requirement. Pension income can also be a part of that income that is allowed. Speak to an immigration lawyer and they should be able to calculate whatever incomes you can use, savings, etc., etc., and whether you meet the financial requirement. So yes, pension income, pensioner in the UK can apply for a spouse visa and sponsor the spouse to the UK. Okay, so what's the procedure to renew BRP card? ILR getting expired next month under 10-year route. ILR 10-year route. Okay. Yeah, you should just apply for a new, not a BRP card. Yeah, you will apply for a new replacement BRP. So this is the question. In the past, BRPs were given and some of them are expiring now. So I think yours is expiring next month. We are in January. Let's say yours is expiring February. You still need the BRPs till December next year, till December this year. You will have to apply for replacement BRP or something and give them evidence that you have been living in the UK since the time you got ILR. They will ask for that evidence. That is very important. They will always ask for it. Council tax bills, any proof that you are living in the UK. The checklist also comes up with documents that you should show to prove that you have been living in the UK since you got ILR till today. So yes, you should apply for that new BRP card. Okay, next question. Did I miss anything? No. What is the UK? Okay, is there no priority service for ILR private life service? ILR private life. So I think if you are talking of the 20-year route, 20-year private life route, I don't think there is a priority service. I remember I just did one, yeah, 2 weeks back. I don't think there is a priority service for the 20-year one if you are referring to the private life 20 years. If you're trying to apply for the 10-year long residence, being legal in the UK for 10 year, there is a super priority service, yeah, but not for the 20-year long residence. Can I set okay. PSW visa and gets expired in 2 months. I started doing an online business. I sell badges. Okay. Maybe can I still get a business or skilled worker visa if I am work on an online business from home? Okay, so this is another question of PSW visa holder trying to set up a business and get sponsor license and to sponsor themselves. So you're doing some online business and selling some articles online. Yes, if it is a genuine business, if it is big enough to sponsor an employee and then pay the employee a salary of 26,200 as of today and 38,700 after the changes come into play after April, then yeah, you will have to justify that to home office. How are you getting the funding to pay such big salaries with that online business? If it is really scaled to whatever levels, then and what that person will be doing in the business. I think you're trying to do self sponsorship on the PSW visa. It is possible provided you have the funding, you have the salaries, you have everything, as I answered for the previous question live that was asked. You're on PSW visa, it's expiring in 2 months, you are doing some online business, you can register that as business. I think on PSW, yes, you can register a business and then try to apply for a skilled worker sponsorship for the business. But then home office will try to check the funding, the genuineness of the business, whether you are trying to sponsor yourself. You will definitely need a local person, someone who is settled British ILR holder to act as an authorizing officer. He will not be able to act as an authorizing officer on that sponsor license. Next question live. Krishna Kumar, turnover 10K a month and bank balance 20K. If I show that would be okay. I got a relative ILR for AO, not an issue. What will be your fees for the application? About any fees and services, please. Yeah, I cannot advise on that. Go to our channel bio or something. There should be a website link and fill up the contact form or email us or call our office and someone will get back to you with whatever fees information. With all the facts that you have given, it may be possible, but home office will definitely come back with questions. It is possible, it's not that it's not possible. I have done uh, several, yeah, someone, various businesses. I cannot get into more details, but yes, PSW visa holders have set up businesses and someone, friend, relative who has acted as their authorizing officer, and yeah, it has been continued. So it is possible, it's not that it is not possible. uh, but yeah, everything needs to be done properly. All the genuineness should be explained, why your business needs, what you will be doing exactly in the business, etc., etc. Yeah. uh, yeah, if you prepare a proper case, it is possible, but remember that home office will try to get behind that sponsor license and try to see what is really happening. Is it just you're trying to circumvent the rules and try to self sponsor yourself and try to get some visa after your PSW? So be mindful of that. But those numbers should be fine. I've done even sponsor license applications with lesser than that numbers, 10K turnover and balance of 20K. Yeah, I've even done less than that much of numbers. So it is possible, it's not that it is not possible. Speak to an immigration lawyer. If you want our advice, you can book our consultation. We can go through exactly all the numbers and advise you what are the chances of success, the process to follow, what is possible, what is not possible, percentage chances, etc., etc. Or speak to any other immigration lawyer and get a proper advice on this. It is possible, it's not that I'm not ruling out, it is possible. So the next question is, okay, quick question. Do you know how fast do fast track increase allocation of costs? Is there any chance to get fast track slot? Yeah, so allocation of costs. So what the individual means is undefined certificate of sponsorship. If you want allocations for that, if you want the certificates, there is a priority service, but every lawyer is having, every day there are only 60 slots of priority. We have always got it. I know currently there is a lot of delay in getting those priority services, but do it through a legal representative and they should be able to secure a slot for you. There is no guarantee that you will get a slot, but yes, there is a fast track service, priority service. By paying £200 for the priority service, the allocation can be increased. You can make the caseworker to look at your allocation request, whether they accept it or refuse it, it depends on that. But yes, a decision can be expedited on the undefined certificate of sponsorship. There are only 60 slots in a day. There are some timelines to be applied. Usually lawyers know this, we do apply for our clients. And yes, you can get the priority service to get an undefined certificate of sponsorship. Next question, is there any chance to get slot for priority for increase of allocation of D costs? Okay, same question. Yes, it is possible to get priority allocation of undefined costs. No more questions on this channel. I'm trying to find if there are any more questions. No more questions. If anyone has any questions, you can ask me now, or I will end this live. This live will be stored on YouTube. Anyone who has asked questions, they can see in their own time. And anyone who wants advice on their specific matters, please book a consultation through the links on the YouTube channel, on our website, wherever, and take it from there. Thank you very much, everyone who joined, and I will try to be live next week sometime. Thank you.